Hello, and welcome to In the Privy Council, a weekly podcast reviewing cases heard before the Judicial Committee of His Majesty's Most Honourable Privy Council, brought to you by the Legal Style blog. I'm your host, Elijah Granite. This week we are discussing the Bahamian case of McPhee and Colina Insurance, the citation for which is 2023 UKPC 8. This case, decided by a bare 3-2 majority, split their lordships into two camps. To understand why, let's begin with a brief overview of the facts. The detail is complicated, but in essence this is a case about a dispute between a life insurance company and an insuree. The insurance company cancelled the insuree's policy after he was unable to pay increased premiums. The High Court and the Court of Appeal of the Commonwealth of the Bahamas found the insurer was able to increase the policy and had fulfilled its contractual obligation. For the majority of the board, led by Lord Woolman, sitting up to the Privy Council from Scotland, the problem at hand was quite straightforward. Mr. McPhee, the insuree, had contracted to a policy that allowed increases, and Mr. McPhee was relying on claims that he hadn't received notice of the rules of the policy, which had not been raised in the courts below, and which had never, that is to say, the fact that he had not received the policy, been demonstrated as fact. In fact, in the courts below, Mr. McPhee had, instead of any of these arguments, focused on unfounded allegations of fraud against the insurer. Given that the trial court had made the most thorough investigation of any court seeing this case, Lord Woolman found that regard must be had to the nature and scope of the contest before the judge. The evidence may not have been perfect, but it was sufficient to allow Her Ladyship, my Lady, Madam Justice Charles, to make an informed decision. Consequently, Mr. McPhee's appeal failed. The dissenting minority opinion, jointly authored by my Lord Legate, and my Lord Stevens of Criviloch-Gair, accepted the facts as put by Lord Woolman. However, they disagreed sharply on the approach. The judges began by considering the question of burden of proof, which had not been raised in the courts below. As the insurance company was claiming a right to payments, it had the burden to prove any facts establishing that right, in this case, contractual authority. Their lordships fixated on the fact that, at trial, the insurer had been unable or unwilling to provide the table of annual rates given to the policyholder, or specify the yearly increases provided for in the contract. Although the facts had not been in dispute, their lordships considered that Madam Justice Charles was wrong to accept that Colina had discharged its burden of proof, to demonstrate that it had the authority to make the yearly increases it did. Their lordships reached similar conclusions about the interpretation of a reinstatement clause, which had been used to justify increases, finding that the lower courts were wrong to be so quick to accept Colina's claims. This dissent is a very interesting one, because it concludes with their lordships acknowledging that Mr. McPhee did himself no favours in the courts below by making allegations of fraud with no proper basis, sacking his representative at the start of each hearing, and representing himself, before adding, "But unmeritorious litigants can sometimes have the law on their side." This is the crux of the issue. Mr. McPhee conducted his case below poorly, one might say very poorly, and only now, by appearing before the Privy Council with proper leading and junior counsel, and seriously bringing arguments worthy of consideration, is he actually introducing these other issues. Is this last-minute change enough to justify interfering with the lower court decision? For the majority, the answer was no, and the chance to prove that these matters already happened and is gone, and all that is remained to be done is to analyze the grounds of appeal. The Sherlocking done by the dissentient minority smacks of an appeal court substituting itself for a trial court, and to my mind runs close to violating the rule in Devi and Roy, despite the efforts of their dissenting lordships to insist they were only disagreeing on matters of law. As much as it's exciting to suddenly find the case wasn't proved, it's hard to see how the grounds were there for a completely different interpretation, when it would have been easy and simple to deal with these issues at trial or even on the first appeal. In light of the unique and special work of the JCPC as a geographically removed appellate court, it is submitted that Lord Woolman's majority approach is to be preferred. Thank you very much for listening to another episode of In the Privy Council, brought to you by the Legal Style blog. If you want more legal content, visit our website, legalstyle.co.uk, or follow us on Twitter @LegalStyleblog. If you have any comments, suggestions, rants, or raves, the email of the podcast is editor@legalstyle.co.uk. We also welcome any ratings and reviews on your usual podcast platforms. Until next time, goodbye and God save the King.